Welcome to Justice for New York. I'm your host, Charles Collins. All documentation concerning Justice for New York videos can be found at justicefornewyork.com. There are also family court petitions concerning the right to a jury trial, petitions to vacate support magistrate and judicial hearing officers' orders as they are issued in violation of the New York State Constitution, and there is also a demand for probation reports and psychological evaluations that the court orders, but the court orders that you can't read them or see them. That is a violation of your right to due process and equal protection of the law. They also order that the people preparing these reports do not have to testify and there is no accountability. This has to stop. Demand your reports so you can know what's being told to the court. And now for our presentation. Thank you. The next issue we're going to address is the Constitution of the State of New York concerning the family court. First off, there are 5 great courts in New York State that are considered constitutional courts. They are the Court of Appeals, the Supreme Court including the appellate divisions, the Court of Claims, the County Court, Surrogates Court, and Family Court. Those are constitutional courts. They cannot be changed or amended without changing the state constitution. All your other courts, city courts, village courts, all the smaller, lesser courts, those are created by the legislature. They get to choose how the judges are appointed or elected. They get to choose what jurisdiction they're going to have and everything else. But the 5 big courts, the legislature has no authority whatsoever to change. Okay, the New York State Constitution, Article Section 13, states that the family court established composition, election, and appointment of judges and jurisdiction. Before we go any further with this, I stated that the New York State's Department of State altered the state constitution. Here's where they altered it. It says family court established, the composition. In other words, who's going to be making decisions in the family court? How are they elected and the appointment of judges. Doesn't say support magistrates and it doesn't say judicial hearing officers. What the Department of State has now done, and if you go to the law library and go to McKinneys Laws, it's still in McKinneys Laws. They changed it to family court, organization, jurisdiction. In other words, what they took out was the composition and election and appointment of judges. They're trying to cover up the illegal actions and the appointment of support magistrates, hearing examiners, and judicial hearing officers that are in violation of the state constitution and family court. Now, family court says, the family court of the state of New York is hereby established. It shall consist of at least 1 judge in each county outside the city of New York and such number of additional judges as may be provided in each county by law. It doesn't mention hearing examiners or support magistrates. Now, I made the argument that these people being appointed as these is unconstitutional. They have no right to hear the matters because the Constitution says only judges. It doesn't mention anybody else. Well, our illustrious appellate division held, if you'll notice, in Corella versus Collins, they don't address what the Constitution says about the appointment of judges. All they do is they state Article 6, Section 13, vests broad powers in the legislature to make procedural rules for the court. So in other words, a procedural rule, what papers have to be filed, what are the hours of the court. Those are all procedural rules. How evidence is to be submitted, all different things. There's a whole section on rules of the court. One was the court is open under Family Court Rules, section 205.4. Then they go on to, they also refer to support their position, Glass versus Thompson. The problem with Glass versus Thompson is, here an examiner was found to be legitimate, but it was in a city court, not a constitutional court like the family court. You're comparing apples to oranges. A city court, yes, the legislature can change the composition of a city court. They cannot change the composition of the family court. So this is a bogus statement in order to deceive and to defraud the citizens of this state. Now, the next thing they put in here, it says, even if the authority vested in family court hearing examiners could be shown to infringe in some way upon the province of the family court judges, any infringement would not be on an unconstitutional grant of authority, because the final authority to review determinations by the hearing examiners is reserved for family court judges. Sounds good. Problem with the thing is, one, they're not authorized, and number two, the judge, when he's reviewing it, cannot determine the demeanor of the litigants because he's not in the courtroom watching them. So how's he going to review it when he can't see how the people were reacting and how they were answering the questions? He can read the transcript, but, you know, reading a transcript doesn't give you emotion or anything else. It's just plain words. That the appellate court is fully aware that the composition and jurisdiction of the family court are not dependent on the procedures the court must follow. The procedures of the court must conform to the state constitution of the family court defined by the state. Vesting jurisdiction in non-judicial employees, which is what they are, they're not judges, to determine issues of support and contempt proceedings for failure to pay support pursuant to court order. That the state constitution has specifically given to the Supreme Court and family court judges upon referral from the Supreme Court is not a procedural rule. The New York State Legislature is not authorized to change the composition of the family court. That's one of the things they're probably going to try to do at the next Constitutional Convention. Vote against the Constitutional Convention. I will guarantee you. They're going to talk about they're going to talk about what sounds good to the public to get you to agree. And then when they get in there, they're not going to address those issues. They're going to address what they want to address. And I will tell you, knowing New York State, you're going to have less rights after the Constitutional Convention than you do now, because they're stripping you of your rights, as I've so far documented, and there's more to come. Court rules must be adopted in accordance with procedures prescribed by the kind statute. And the legislature may not constitutionally regulate the details of the manner of performance of the court's jurisdictional mandated duties. They have no authority. The law is very clear. They're covering it up. Governor Cuomo, Attorney General Snyderman, Senator Schumer, and Judge DeFore. The New York State Constitution is very clear when it comes to judges being in family court. As it states, it shall consist of at least one judge in each county. There is no mention in the state constitution of hearing examiners or support magistrates or judicial hearing officers. Therefore, they are not authorized under the state constitution. The argument that the appellate court gave that it was a procedural rule is a crock, and every one of you as attorneys know it. If it was a rule or a procedure, it would have been under the uniform rules for family court, such as that family court is open to the public, which was another crock. For 20 years it's still been closed, and it was a lie when they stated it was open. All support magistrates and judicial hearing officers need to have their jobs terminated immediately. They are illegal and they're operating in violation of the New York State Constitution. Further, everybody out there, next year they want a constitutional convention to amend the state constitution. They claim it's for pensions, to reduce pensions for politicians convicted of a crime. I will tell you, it'll probably never pass. But all the issues they're not telling you will pass. It's going to be a bait and switch scheme that the courts use and the politicians use. Do not vote for a constitutional convention. They don't follow the Constitution as it is. Why would you want them to amend it so they can violate your rights even more? Saying, well, it's now a constitutional requirement. They're out there. This constitutional convention is no more than a fraud that's going to be committed upon the citizens of the state of New York. In the meantime, the hearing examiners, the support magistrates, and the judicial hearing officers all need to be fired. They're not authorized. Nobody should be forced to appear before any of them. Do your jobs and fire them. Follow the Constitution for a change, instead of covering up the illegal actions of the judiciary when it comes to the Constitution.